Now we are going to see about the appointment of directors. Section 149 says an individual can be a director. That means a company or a partnership firm cannot be a director. Previously they were permitted to be a director, but now only an individual can be. All the directors should have a director's identification number. Director's identification number all the directors should have. Then the same section says the public limited company should have a minimum of 3 directors, private limited company should have a minimum of 2 directors, and 1 person company 1 director. The maximum is 15. This can be extended further by passing a special resolution. Section 149(4) deals with the independent directors. All listed companies should have 1/3 of its directors as independent directors. Then who are all the independent directors? The same section says it's a detailed one. We will see one by one. The independent directors qualification is person of integrity and possesses expertise and experience. Some people may be experts. Their knowledge and their expertise should be used in the company. That is why these independent directors are coming in. What the owners view the company will be different from the persons who is viewing the company operation from outside. They may have a better idea because of their expertise. So there is a provision that 1/3 of the directors should be independent directors, and they should be a person of integrity. Expertise and experience should be used for the company. That is why this concept has come. But there are some restrictions. One is the person should be of expert in his field, expert and experience in his field. Next is he should not be the promoter. A promoter cannot be appointed as a independent director. Same is the case. A relative of a promoter cannot be appointed as a independent director. If you are restricting a promoter, he should not come with his relative to be appointed as a independent director. There is a restriction. Promoter and independent director cannot be appointed. Next is pecuniary relationship. This pecuniary relationship, there is some financial dealing with the company. A person who has lent money to the company or who is having dealings with the company. Any person who has a pecuniary relationship with the director, promoter or the company or the associate company, holding company cannot be appointed as an independent director. Pecuniary relationship. What is a pecuniary relationship? The Act says 2% of the turnover. A company is a 2%, more than 2% of the turnover is dealt with the pecuniary person. Then that person is deemed to be having a pecuniary relationship with the company, or if he has income more than 5 lakhs. For example, a firm giving advice regarding some technical matters and charging 10 lakh rupees, then there is a pecuniary relationship. Some architect firm advising the company and charging 15 lakh rupees, then there is a pecuniary relationship. Any pecuniary relationship with the company may be holding company or associate company, with the director or the promoter cannot be appointed as a independent director. Then the next is the relatives. If anybody is related to this person, then they also cannot be. If a person is dealing with the company and since there is a bar on appointment, he should not come with a proposal to appoint his wife as a independent director. Any person or their relative cannot be appointed if they are having a pecuniary relationship with the company. Pecuniary relationship with the company means more than 2% of the turnover is dealt to the company or having income of more than 5 lakhs. This is regarding pecuniary. Next is regarding the managerial capacity. Key managerial person cannot be appointed as an independent director. Key managerial person in the company or associate company cannot be appointed as the independent director. He holds or has held the position of the key managerial person or has been employee of the company cannot be appointed. So a general manager or a person who is working in the company in a key managerial post cannot be appointed. Not only that, if a person is working in associate company, he cannot be an independent director in the holding company. Key managerial persons are prohibited from taking appointment as independent director. Next is regarding that auditors and the legal persons. Any form of auditors or company secretaries in practice or cost auditors of the company, the holding company, subsidiary company or associate company. Any person who is the auditor of the company, that is any partner in the firm which is auditing the accounts of the associate company or subsidiary company or holding company, cannot be appointed. Same is the case with the legal matters also. Any legal consulting firm cannot be appointed as a independent director. Further, there is any relatives, any person or a relative who holds more than 2% of voting right cannot be appointed as a independent director. Next is, if there is a charity organization and more than 25% of its charity organization funds are coming from this company, then he cannot be appointed. These are the total restrictions. First restriction is on promoters. Second restriction on persons having pecuniary relationships. Third restriction on persons who are in the key managerial positions. Fourth restriction is on the persons who are the auditors or legal firm. Fifth is on person having more than 2% of the voting capacity. Sixth is on restriction is on the person who is taking a charity funds from the company. Now, if a person satisfies all these, he can be appointed as a independent director. He has to give a declaration that he is eligible for appointment and he will not come under all these restrictions. That is subsection 7. Next is regarding remuneration. The independent director can take fees for attending the meetings. He can get reimbursement for travels and all, but he cannot exercise a stock option. Stock option means the company will be giving shares to the person. He cannot take that shares. The next is a period for independent directors. Period for independent directors is 5%. He can be reappointed next time for another 5 years. So, after 10 years, there should be a cooling period of 3 years. He cannot be appointed in the company as an independent director for the next 3 years. And after that, he can be appointed as an independent director. Next is regarding the liability. An independent director is not liable for the activities of the company. But in case he knows the thing and he is also party to that any activity, then he will be liable for that. Next, regarding the manner of election, the Act says central government will notify some authorities for keeping a data bank about the independent directors. It is the duty of the company to get the data from that data bank, select the independent directors, and it is their duty to do the due diligence, whether the people are having the required experience, expertise, and having persons of integrity. That all things, background verification should be done by the company. It is company duty. They will give only the data. Next is regarding appointment of shares for the small shareholders. Section 151 deals with this. Small shareholders means a shareholder who has invested in the company for face value of shares less than 20,000 rupees. One director should be elected by these small investors. Next, regarding first directors. First director. Who are the first directors? Unless otherwise specified, in the memorandum that these people will be the first directors. All the subscribers to the memorandum are the first directors. The next set of directors will be elected in the next annual general meeting. Now we will see how a director is appointed in the next session.